Ke a koe matua, Kevin?
Kei nei tātou. E pae tō matunu I te rangi. Ko mātou hoki, tonu oku ene, aupononga, e hono tune I rungo I te ipurangi, ki te whiriwhiri ngā take pāna ki ngā plako o Waipaoa. E ino tunu mātou ki a koe pā, ki o manakitina koe ngā roia, me ngā rātou kai kōrero, kia māramai a rātou whakāturanga ki mua I te auroro o te tēpū I tēnei rā. Tuku e koe te māramatanga me te aronui kia mātou te tēpū e pā, ki te hopu I ngā kōrero, ki te tātari I ngā kupu, ki te whakatatu I ngā take, kia puta kone pai ngāna mo tiwi katoa e whaipā ngāna ki tēnei kaupapa. Manaki tino ki koe e tau mātou hea mana, te kai whakawā milroi, ki te arahi a mātou I runga I te huarahi o te tika, kia tutiki pai ai, tōna whakahaere I tēnei noho mātou te rānei. Kaupare atu koe ngā wairua kino me ngā wairua pope kia kore o ki uru mai ki roto I tēnei hononga e mātou. Kia maharana kuhe ki ngā tūroro, e taimahana I te mauiwitanga I roto ki ngā kāinga me ngā hoipere, kia tautore tau wairua whakaora ki runga I a rātou. Ko te ino ki tēnei kia koe pā, kia tatutonu mai kia mātou, kia piritonu koe kia mātou, mō te roanga ki o tēnei hononga ki tīpurangi, maune whakamana mai, āke nei, āmene. Kia ora tātou.
Kia huataki ake ngā mihi, kia mā turuturu te tōmairangi o tōna atawhai ki runga ki tēnei huihuinga. Kei ngā tinimate o te wā iti nei, hoki atu rā ki ngā ringakaha o te atua, ki te whare mā koha I te rangi. Tēnā koe matua Kevin I paihere I a tātou ki te taha wairua, e ngā mana, e ngā reo, e ngā iwi maha kua uru mai nei I runga I te kaupapa o te wā, nau mai, haere mai rā. Aku mihi nui ki ngā kaikareme me o rātou roia, ki te corona me ōna mānga e kōrero, ki aku hoa o te rōpū whakamana I te tiriti. He mea pai ki te mihi kia koutou I roto I te wiki o te reo Māori. Ko te tūmanako mā tēnei hui e whakamārama te huarahi whakamua. Nā reira, tēnā koutou, tēnā koutou, tēnā koutou katoa. Welcome to this second judicial conference for the Waipaoa Remedies Inquiry. I'll just begin with appearances, and rather than asking you one by one to appear, I will just go through the RSVP list and just ask you to confirm. So firstly, Ms. Faint.
Tēnā koe e te kaiwhakawā o tēnā koutou e te rūpū whakamana i te tiriti o Waitangi. Huri noa i te whare tēnei te mihi atu ki a tātou i te ata nei. Ko Karen Faint tōku ingoa he māngai roia mō te aitanga a māhaki.
Tēnā koe, Miss Faint. Ngātahi Law.
Tēnā koe te kaiwhakawā. Ko Tony Sinclair tōku ingoa mō Ngātahi Law. A council appearing for Y87 Whakatohea Raupatu claim and also Y1794 Tūranga Piki Toi claim, along with my learned counsel Mr. Brett Cunningham, who's also on the conference, ma'am.
Tēnā kōrua. Mr. Sharp.
Tēnā koe te kaiwhakawā, ko Michael Sharp aho, appearing for Y2160 Ngāti Merawai.
Tēnā koe, Mr. Sharp. Wakro Panoho.
Tēnā koe, ma'am. Raywin Clark, appearing for Ngai Tamahoa Y1781. Thank you, ma'am.
Tēnā koe. Mr. Benyon.
E te kaikarakia tēnā koe, ngā me mō te rōpū whakamanu Treaty o Waitangi tēnā koutou. Yes, Mr. Benyon for Y507, ngā ariki kaiputahi claim and Mr. Lloyd. Kia ora.
Kia ora. Kokiri Chambers. Ms. Shrew. Kia ora.
E te whakawairoa te kaituku karakia tēnā koe. Ngā mema o te rōpū whakamana i te tiriti o Waitangi, tēnā koutou, ko Laia Lahau, ko Ms. Shreem tēnei, ka tūnei maua mō Y499 me Y874, ngā mihi te kaiwhakawā.
Tēnā kōrua. Mr. Kahukiwa.
Atamari e Yorama.
Atamari e.
Kauki o tēnei for Y995, rangi whakataitai a Wihā o ngā Ngāti Matipu o te aitanga a Māhaki. Kia ora rā.
Tēnā koe. Ms. Dixon.
Morena i te kaiwhakawā, kia koe hoki e pā mō ko karakia mō mātou i tēnei ata, ko Kelly Dixon tēnei, kei konei ahau mō te kreme Y892, a late entrant into the proceedings, ma'am, and also a late filing of a brief memorandum last night, just setting out the position for Te Whānau Kai. Also wish to record the apologies of Mr. Chris Finlayson, who is instructed also on this matter. Nā koe.
Kia ora, thank you, Ms. Dixon. Ms. Sykes.
Ko te tuatahi kei te tautoki ngā mihi ko mihia, e te tuhunga whakatūpira tō tātou nei hui tēnā koe. Koutou mai kia nei te rōpū whakamana i tō tātou nei treaty, i tēnei wiki o te reo Māori tēnā koutou. Ka hoki aku mahara i nai nei tētahi wahine rongonui o te ao i ina nahi rā, ko Joe Mitch, ana moi mai rā e te wahine toa, e te wahine koe, e te wahine whakaaro hohonu mō tō tātou nei whenua rangatira Aotearoa rō nei. Ana ka huri au ki te kanohi ora tēnā tātou. May it please the tribunal, I just learnt sadly that Dr. Joan Mitch passed away yesterday, and she was a long time participant during the fisheries dramas in the Waitangi Tribunal and a significant contributor, I think, to the peace of this country, and I wish to think of her today in this week of Te Reo Māori. Her contributions to biculturalism, I think, are second to none in this country. Secondly, I endorse Your Honour's wishes to many of us that are sitting under the kapua pōuri at the moment, but I'm also very aware that there are significant tribal leaders that are unwell, and I hope that they get well at this this time. I'm representing today Ngāti Ira, Irapuaia or Waiawika, Y558. I'm also instructed today to make an appearance for Ms. Cole with respect to the Motohora quarry claim. She has been in negotiations with the Crown up until recently on the expectation that their issues may settle. We now had a letter from the Crown confirming that's not the position. So she will be filing a memorandum seeking leave to be a late entrance, like my friend Ms. Dixon, and with your Honour's leave and the Tribunal's leave at due time, would like to make an application to be heard for her claimants. Motohora Quarry is quite significant. It has a mix of beneficial owners, including the Mangatua Corporation itself, and a number of people of both sides of the divide, if I might say that. So they're quite unique in the position, if they are granted leave to enter, that they will bring to this hearing. And I act for Ngāti Ira, as I said, or Waiawika. Kia ora.
Kia ora. Thank you, Ms. Sykes, and thank you for letting us know about Ms. Metch's unfortunate passing. I used her materials in my lecturing when I was lecturing at law school, so it's a sad thing to hear that she has gone. And finally, Oranganui Legal.
It must be that time of the year. I also would like to acknowledge the passing of the named claimant for Y78 Ngāi Kai, Ms. Miriwai Jones, passed away over the weekend and was an amazing woman to work with. She contributed greatly towards kapahaka, both participating in Tamakatini and judging as well. She will be missed by the iwi, and it was a beautiful tangi that was held. So I appear today on behalf of Y78 Ngāi Tai. Thank you, Mum.
Kia ora, thank you. And the Crown, let me not forget the Crown.
Oi, te kai whakawā koutou ngā mea mō te rōpū whakamanu I te tiriti o Waitangi tēnā koutou. Ka huri ki ngā roia and kai kareme tēnā koutou katoa. Craig Lincoln with Daniel Hunt for the Crown today, and we have an official from Te Tari Whakatau, the Office of Treaty Settlements, to observe with us as well. Thank you.
Tēnā koutou, thank you. And I believe we are also hoping that Ms. Miles from the CFRT has not yet joined us, but is intending to do so. So thank you for your appearances today. You'll have had the agenda, and we have received the joint memorandum of council and also a couple of other memoranda, one from Mr. Sharp and also one from Ms. Dixon, your claimants, the Te Whānau Kai. And we haven't had all that much time to read them, so I will probably ask you to just address them as we reach each of the topics to which they're relevant. Just to explain the agenda, it seemed to us in preparing the agenda that the items in terms of timelines, the research and then the amended statements of claim were all tied together. And the joint memorandum of council has been helpful in setting out what the proposals are from council in terms of how this inquiry can progress from here. If I can just briefly summarise what we're understanding the situation is, and there will be a point at which I ask Ms. Dixon to contribute at this portion. So our understanding is, first of all, that the Manga Orongo block, just to tick that off the agenda, the Manga Orongo block, there's general agreement that that block can be included in the inquiry for contextual purposes. and particularly in relation to showing customary interests in the area. If I can indicate here now that and we will do it formally, that we will include the Manga-Orongo block in the boundary for the inquiry for those purposes, for those contextual purposes. Being careful not to reopen anything to do with the East Coast inquiry. So that's that matter. Now, just in relation to that grouping of issues around the amended statements of claim and research, our understanding from the memorandum is that, if I can put it this way, the tūranga grouping of claimants are in the process of obtaining their research and expect to have that within 2 to 3 months. And so my thought was that we would be looking at setting a time frame for that, with that evidence to come in December. And so I just wanted to check with Council that that was your intention, and so that we can set that as one of the timeframes for this inquiry. So perhaps Ms. Faint, if you would like to respond, and then I'll ask the other tūranga claimant Council to say anything that they need to.
I think, ma'am, can I say 2 things? First, on the Manga-Orongo block, it may be relevant not only for contextual purposes but also as a claim, because depending on the interpretation of what relates to Crown Forest land means, it may be that a claim can be established for that block, which I understand is within the vicinity of the Waipaoa area, and that's why it's relevant. And as I noted in my memorandum for Te Aitangara Mahaki, that's a block that was awarded to Ngāi Tamatea, and the circumstances in which it was alienated to the Crown as soon as the Native Land Court had determined title, suggests that there might be a legitimate claim there. Secondly, in relation to the amended statements of claim, where we've got to in our discussion between Claimant Council and the Crown, we had a discussion last Friday, we agreed that we really need to all proceed together in terms of the evidence, because, as my friend Ms. Sykes pointed out, the whakatohia affiliated claimants won't be in a position to cross-examine our witnesses until they have their own research completed, and vice versa, the Mahaki claimants and the associated groups would be disadvantaged if they have to file their evidence in advance of the whakatohia claimants, because then the whakatohia claimants can respond, but we would need a right of reply. So where we got to roughly was that because we think that the hearing as a whole was not going to need to be very long, I think Mr. Linkhorn was going for only 1 week, but the rest of us thought it might be more likely to be 2 weeks, depending on the extent to which customary interests are contested. And then the most efficient process would be for everyone to proceed at once and have one comprehensive hearing at one time, and that would in turn suggest that the best way to proceed is to have the same evidence filing deadlines for everybody, and then have rights of reply for everybody.
Thank you, Ms. Faint. I just need to, it's a bit backwards really, but if we look at the hearing, I think it's wise to set aside 2 weeks in any case, just in case there's overflow from the 1 week. And in terms of the inquiry, the tribunal planning, they definitely need to know if there's needs to be 2 weeks of funding set aside. And it's safer to have 2 weeks in that case. So were you anticipating that those weeks would be back to back, which personally I'm not in favour of, because it's very hard on the tribunal panel members, not to mention the claimants and counsel. So, yeah, just an idea of how that process, the hearing process, what you're looking at in terms of that, and then working backwards from there in terms of the filing of the evidence.
Well, we're in your honour's hands as to whether those weeks are consecutive. I do take your point that it's a lot more difficult. I mean, one way of doing it would be to have all the evidence heard in one block and then have a gap and then have closing submissions, or to have all the claimants proceed with their evidence in one block, then have the Crown respond if it's going to file evidence later, and then have closing submissions. So we're not necessarily saying it has to be one hearing of consecutive weeks, but the short point is that we think that it can be fairly truncated because we're relying on a body of research and evidence and findings from another tribunal inquiry in the case of the Turanga claimants, and the settlement and the ongoing inquiry for the Whakatohea claimants.
And from the memorandum, we're looking at the April to June period next year for hearing. And I must say now that my April and May are already chocker, so we're looking at June really. Working backwards from there, we're looking at, say, all the evidence being filed by March and reply from the Crown in April, possibly into May, and then any reply evidence after that, and then hearing in June.
Well, that would suit my claimants, ma'am, but you might need to check with the Whakatohea claimants first, because I understand there's some difficulty in getting researchers, so
yes,
I'm not sure what their timing looks like, and I think the reality is we can only go as quickly as the slowest groups.
Yes, thank you. And this is where I need to ask you, Ms. Dixon, are you able at this stage to let me know what the likely time frame for Te Whānau Kai would be in terms of research?
At this stage, ma'am, I can't give you a approximate kind of date, but we're happy to work as efficiently as possible with the other Turanga claimants to ensure that we can meet the proposed deadlines that you've just indicated now. I'm sure that will be doable for the claimant.
All right, thank you. Mr. Benyon or Mr. Lyle? Well, perhaps if I just start with Mr. Benyon. Yes. Did you have any?
Yes, yes, Your Honour. So we talked to our researchers, Mr. Anthony Patete, and he was at a call with him, I think, 48 hours ago. He can produce a report by March next year. We were thinking he might do it this year, but it will be March next year, so we can certainly meet that time. There's just a question about, I think we're going to, Mr. Lyle's clients who are also Ngā will, I think, be relying on the research. I just have to clear with my clients that it's a kind of Mr. Patete's evidence would be relied on by both. As a matter of practice, that would be the case anyway. It's just a matter of formalising how that arrangement works between us. But certainly, we've got a researcher can produce a report by March next year in time for the hearing.
Thank you, Mr. Benyon. Mr. Lyle, did you have anything to add?
Your Honour, nothing to add. My client's tangata whenua evidence will be able to be prepared well in advance of any March deadline, and as Mr. Binion said, we anticipate the CFRT funding will be used jointly to prepare Mr. Paitete's report in a way to be efficient and not have a double up of researchers in front of the tribunal.
Kia ora. Thank you, Mr. Lyle. So this then brings us to the whakatōhea grouping of claimants and ngaitai. So I will just ask perhaps if we begin with you, Ms. Sykes, and what your claimant's situation is in relation to research and possible filing dates and so on.
Can I just say I have a different proposition around the hearing proposal. I would like a mediation on customary rights and interests. And I know that some of my yet-to-be friends from the Te Aitanga Mahaki and other groups have to be persuaded to the efficacy of that approach. But in my experience, when there is a dispute around whether there is customary rights and relationships to a particular area, that will have impact ultimately on how the hearing will be conducted. And I've been involved intimately in two particular cases. The Motiti case is, I think, one of the ones where a hearing that I thought might have started with a 2-week scheduling program went to nearly 4 to 6 weeks because of the internecine issues and conflict between each of the various parties asserting rights and interests to the particular area. And some of the issues I thought in that case created such deep embedded division that if we could use the new powers of the tribunal for mediation, which I know will only happen if there are consent of the parties to that approach, to actually do whakapapa, cross-examination in a much more neutral way and less contested way, and one about educating everybody to why people are claiming participation or interests or relationships to areas that others dispute. So that's my consideration. We did that, and this is the second example, in the Kawika and Gravis dispute. And ultimately, my claimants did not get recognised in there, but the mediation, I thought, was very helpful. And that was, again, a divide, the Kawika ranges, between interest in Heretaunga Tamatea and interest from Mokai Pātea. That process, which was facilitated by two very senior members of the Waitangi Tribunal panel at that time, was a very helpful way of, one, limiting conflict, a better exercise of time than just lawyers cross-examining, and a facilitation that I found helpful. I tried to persuade my friends to the benefits of that approach, but I understand that some parties are quite firmly of the view, that until there is evidence of prima facie rights and interests in either of the blocks or the Waipaoa inquiry area, if I use that as a better descriptor, they don't see the value in such mediation. I'm of a different view. I'm saying that quite often whakapapa evidence given in a sensitive way can actually avoid cross-examination. And quite often it's the intimacy of those connections that if they are said, if it's evidence given in a sensitive way, particularly evidence that may bring to mind some of the atrocities of the early New Zealand Wars period and the impacts on individuals that, for certainly Ngāti Ira, that were killed at Maraetai and then escaped with the help of Te Kōti, some of that evidence may be actually a bit different than how we might proceed. So I would be seeking, before we commenced hearings, a mediation and submissions on what are the customary rights and interests relied upon in the particular area. And even hoping that if Council could develop a memorandum of consent about ourselves, about uncontested peoples in those areas. I can say, for example, my people have been in discussions with the Mangatua Corporation, and they have no exception at all to the claims being made into the Waipaoa area by many of those hapu that affiliate to that incorporation, just to give you my instructions at this point. So we could consent that those relationships exist. We would argue, as the Supreme Court has found, that many of the relations in that area, Waipaoa, are what we might call as shared exclusive arrangements that have arisen because of the necessity for survival following the disbandment and the, for my people, the forced removal of them from their lands into the interior to avoid capture by the Crown, and which subsequently saw significant relationships and marriages occurring with them, the people of Maunga Pohatu, and many of the hapu that affiliate, including Te Whanau Kai, to the areas that were considered in the Mangatū inquiry. So that's why I would ask for a 2-day possible mediation, if I can persuade my friends to that end. If not, then I don't have the confident view that my friends are expressing that we will actually only do everything in two weeks. I anticipate that there will be vigorous cross-examination using old Māori Land Court records, using, as I think some of our statement of claims have already suggested, some of the highly contested issues arising from the Tāhora block and the Wepere Trust beneficiaries list, which I think will be tedious and take significant time. And that customary rights issue is fundamental, where we're claiming to Crown Forest Assets land in terms of the Section 8 obligations that we have to satisfy to impress upon the tribunal we have rights there. I would say that this could blow out to internecine warfare of the kind I saw in Mōtiti, and a hearing that should have taken 2 weeks go to 4 to 6 weeks.
Kia ora. Thank you, Ms. Sykes. Would you see this, you mentioned that the mediation, if it was agreed to, would take place before hearing, but would that happen after evidence had been filed so that people had that information available to them?
I would anticipate that would be the best way to do it, Mum.
Right.
If not full evidence for the hearing, at least sufficient evidence to give confidence to the facilitators of the mediation that there are not notional interests, but there are actual customary rights and interests and whakapapa relationships that subsist there. People may not accept them, but they are being asserted by the claimants asserting their position.
On the basis that the evidence would be filed beforehand, when do you think your claimants...
So this is our difficulty. Yeah. You will be pleased to know Crown Forest Rental Trust has actually funded us. And so Ms. Cole would be part of the cluster of our research group, and that's already been agreed to. We can't find a researcher. We have found one. Her name is Dr. Jane Luton, but she's not available to even commence a brief until March. We are very anxious to secure her to avoid duplication of effort on her part, because she has been one of the primary po kōrero or po rangahau researchers in the current North-Eastern Bay of Plenty inquiry under the guidance of Judge Dugan. And she already knows many of the parties and is very familiar with the cross-fertilisation of interests on the Mangatū, Waipaoa catchment area and those that we are suiting. So it would be really good to have someone that knows those matters than rather get someone who's never actually researched that. The other difficulty too is that the archives have been closed down, and so I'm using researchers to finish research in the Whakatohea area. And so we've had to get special arrangements in place to enable, for example, research now being commissioned by us by Dr. Sterling, by Mr. Sterling, to be completed in the Whakatohea. That arrangement has already blown out most research briefs by 2 or 3 months because of the difficulty to get into the archives to get the material without appropriate directions or some security arrangements made for that research to be accessed. That's why I'm not confident that even if Dr. Luton could come earlier, we'd actually make it any faster to a time frame of May. I'm saying honestly, that's my concern. My friends from the Crown, I want to say they've been really helpful in suggesting other researchers to us, and we are following up on those. But my instructions at this stage from both of my claimant groups I'm representing today are to maintain, if at all possible, Dr. Luton is our preferred researcher for the reasons I've articulated.
All right. Thank you, Ms. Sykes. So if I understand you correctly, she'd be available in March and be able to produce the evidence by May.
Yeah, we're hopeful. Yeah. We're hopeful only because she's done so much of the research as part of her current research briefs, because she's done 2 briefs now in the North Eastern Bay of Plenty inquiry.
All right, thank you, Ms. Sykes. Mr. Sinclair, do you have...
Yes, ma'am.
Can you advise the tribunal about your research, the situation of your claimant's research, and what sort of time frame you're looking at?
Thank you. Before I go to that, ma'am, in regard to Ms. Sykes's mediation proposal, I have taken instructions from our clients on that matter, and there is some merit in that from our clients, ma'am. So I just want to put that down for the record. In terms of research, we've met with Crown Forest Rental Trust. The Ngāti Muriwai Authority Trust is an approved client of the Crown Forest Rental Trust for the purposes of the Waipaoa Remedies Inquiry. Seeking a suitably qualified historian is a bit of an issue, in particular if we have to provide evidence by the month of February or April. We haven't engaged a historian at the moment, but we are in negotiations. The historian's made it clear that if he takes this commission, he won't be working over Christmas period. He's got to have that off, otherwise he'll no longer be married, as that's what he tells us. But he says that if he could have a date somewhere to the end of April, May, he'd be able to provide a technical evidence brief. On top of that, ma'am, we've got some oral and traditional evidence we're compiling, and we should have that ready by February, I'd say February, around April, February. That's all I've got to contribute, ma'am.
I won't ask you for the name of the technical witness you're looking at, because we might be breaching his privacy given what you've said. But if you're able to provide that in a memorandum at some point, that would be helpful.
As soon as he's signed the contract, ma'am, you'll get it. But I don't want to disclose who it is at the moment.
All right.
Only to say, ma'am, that he's suitably qualified, and we particularly want him for this particular project. Thank you.
All right. Thank you, Mr. Sinclair. Mr. Sharp.
In my recent memorandum, I've outlined what Mr. Sinclair has just discussed, because we're part of those discussions with Crown Forestry Rental Trust. So it's exactly the same position, where there'll be a joint memorandum sent to the tribunal once we are able to confirm any arrangements with the historian.
All right, thank you, Mr. Sharp. And just in relation to the suggestion by Ms. Sykes regarding a possible mediation on customary interest whakapapa matters.
Yes, but I haven't taken instructions on that, but I will do so and revert.
Thank you. Ms. Clark.
Thank you, Mum. We have not filed a separate memorandum. We are, however, parties to the joint memorandum. And to briefly update, CFRT has been very helpful, and we're working towards obtaining approved client status with them. So we're a little bit behind some of the other parties who have already spoken to you, but with their help, we hope to have that secured as soon as possible. We have also had preliminary discussions around a possible historian. That's very early stages only, but we do see some possible pathways there. Ms. Sykes has mentioned the May date, and that would seem like a reasonable date from my perspective, Mum, given the preliminary discussions that we have been having. On the mediation point, I'm not in a position to say anything concrete on that. I will be taking instructions and keen to continue with this conversation around whether a mediation is a good pathway forward. Thank you, Mum.
Thank you. And Ms. Rongo.
Yeah, Mum. In terms of the mediation, I don't have instructions yet on whether our clients support that. But we are having discussions at the moment about the pros and cons, and we'll be able to get back to you on that. Y78 are actually going through the process and having the named claimants amended on the claim. It's been filed with the tribunal and it's going through internal process because we've had some, one named claimant in particular refused to come off. And so we've sought the tribunal depart from their usual policy and able to whakamana the decision of the iwi in that regard. So we're waiting on the tribunal's decision on whether that will be done. And the reason why that's important is because we need to have the named claimants to make the application to our Forestry Rental Trust to become an approved client. We worry that process is taking too long. This is an inquiry that is moving at pace. So we have Mr. Sharp for Ngāti Muruai has reached out to Ngātai to ask if they would be part of their group in terms of getting research done. Given the whakapapa connections, my clients are amenable to that and would look to decrease the amount of time it would take. And there would be some double up and crossover anyway on that evidence, given Ngāti Muruai's whakapapa connection to Ngātai. So we are in discussions with the clients and with Mr. Sharp about how that would look and how that would play out. But that is where we are at the moment, looking to speed up getting our research done so that we can have our amended statement of claim filed with the tribunal.
Thank you, Ms. Rongo. Mr. Kahukiwa, I'm not sure that, I'm just checking whether you were party to the joint memorandum, and if not, would you like to advise us as to your claimant's research situation?
Oh, thanks, Your Honour. No, I wasn't a party, well, I'm not a party to the joint memorandum. I was missed out of the loop. So I wasn't part of the discussions. But if I had have been, I would have supported what the joint memorandum laid out. The irony of all of this, of course, is that part of our claim is that my clients have been invisibilised from this whenua, and now we seem to have been invisibilised with this inquiry. But I thank Your Honour for including me. One thing that I would say in relation to this the geographical scope of the inquiry district. I haven't made a formal play for it yet, but we're doing some thinking about whether, in addition to manga orongo being included, whether manga tai kapua ought to be included as well. A couple of reasons for that is it fits the contextual criteria that manga orongo does, in that its western boundary is shared with Mangatu number 1. Its northern boundary is shared with Waipaoa number 2. So, it does have that commonality of being adjacent. And of course, part of our case is going to be that, well, in terms of traditional times, none of these surveys were present anyway. But we're doing some work on whether we're going to make a formal application for the inclusion of that block, Ma'am. But I can't indicate that today. But just to say that we're working on it, and hopefully soon we'll be able to make a decision on that. Right. In terms of mediation, I think my friend Ms. Sykes poses that's quite a good suggestion. I'm not sure of the details. One of the details that I had in my mind, does that mean that the Pākehā historians turn up as well, or is it just hapu people? But look, I'm sure that my clients would be amenable to that. My experience in the past with these sorts of things is that, much of what is said about traditions in the past, can be a bit misconceived in an adversarial process like this, and so just the sharing of information and how that whakapapa relates is a useful. That's a useful step in this process, and that mediation seems to be quite a good way of traversing those sorts of matters, Your Honour.
Thank you. Sorry.
And lastly, just in terms of the timeframes, we're ready to go on. Just as soon as this hearing can be fixed, Mum.
All right. Thank you, Mr. Kahikiwa. I'll turn to Mr. Lincoln, to the Crown now. There are a number of issues that were mentioned by Council. Did you have any submissions you wish to make about them?
Kia ora, Your Honour. Can I just start by apologising to Mr. Kahikiwa? We coordinated that most recent memorandum, and we absolutely overlooked his participation. I think I know how it happened because of one set of exchanges and a prior hui and all the rest of it. But nevertheless, we should have picked that up. So I'm very sorry about that. And we'll obviously, for our part, in doing future work on joint memorandum, make sure it doesn't happen again. Can I turn to the mediation proposal as articulated by Ms. Sykes? As I heard it explained to the tribunal, I was reflecting that it's quite a carefully calibrated proposal to meet both, evidential requirements should the full hearing need to proceed without a successful outcome from a mediation, but also to make space for the possibility that a mediation would really deliver an efficiency gain for your work as a tribunal panel. So my contribution to today's hui would be to suggest that room is built in for that to be both explored further as between the parties, but also for the tribunal to make provision for it to possibly occur. And in terms of the sort of timeframes we seem to be talking about, the first part of next year, as people are really working on how they would describe things with their evidence, and the sort of proposal that Ms. Sykes made, that the evidence would be put in, and then this could occur, would be the time frame in which to work it up in more detail. Obviously, it requires consent under the statute to use that process, and so it has to be developed in a way that will work and make sense to the participants for it. A possible fallback, if that statutory mediation to address those elements of the claims weren't supported by enough people to have a sort of minimum viable critical mass, as it were. A possible fallback is for the tribunal panel to think itself about a slightly different mode of inquiry for the part of your inquiry that's looking into the customary interests in the land. And that's to be conscious of both the risks of importing from the ordinary court system something that's too adversarial for this context and kaupapa and subject matter, but I suppose also looking for, again, the sort of efficiency gain that you might get from something that isn't purely one person giving evidence and then a cross-examination by every other claimant party, etc. So again, a possible fallback. I can't articulate it in any more detail than that today, I expect. In terms of timeframes, I don't have a lot to add beyond asking that there be a minimum of a 4-week period from the receipt of technical expert reports from witnesses for claimants through to the Crown filing its technical evidence in response. And on the other sort of general point about filing timeframes, we've endeavoured to file statements of response as soon as we can, but we would see the outer time frame for a statement of response to an amended claim as being 20 working days after the statement of claim or amended claim is put into the tribunal. And so if the tribunal's starting to think about a close of pleadings date, or how everything has to be locked down at some point ahead of your hearings, then we'd ask for that to be recorded with that in mind, so that as at the final amendments to claims, there's a response period for the Crown. As for when the hearing can be, we obviously want it to be as soon as reasonably practicable, but we hear all the points that Counsel for Claimants have made today about securing the most appropriate expert who understands their group's situation. So we'll go with what the tribunal wants to do there in terms of communicating expectations after today's judicial conference about how fast everyone should work here. Unless there were other particular matters, I think that responds to what I've heard from Claimant Counsel so far today. Kia ora.
Kia ora. Thank you, Mr. Linkhorn. It did seem from the joint memorandum and various other memos that Council had filed before that memorandum that people were looking at updating their statements of claim, amending their statements of claim as their research reached certain points where they could do so, and then that the Crown would then respond. So it does seem to me that the very last day that anyone would be able to amend their statements of claim would be the same date as the filing of the claimant evidence, and then the Crown response and evidence would then be filed simultaneously 20 working days or 4 weeks after that. Does that
That would work, Your Honour.
Yes.
Yes, that would work. Thank you.
All right, thank you. And just in terms of the amended statements of claim, I do take cognizance of what I think Ms. Faint and perhaps other counsel, Mr. Bennion and Mr. Lyle, have said about this process not being exactly the same as a court adversarial process in terms of those technical documents. All I can say really is that it is helpful, though, for the tribunal in terms of report writing to have clear focus in terms of the issues, and that's what the statement of claim process is about, of course. So if I could just make those comments in relation to that matter. One of the matters we've got left is the maps, which we're very keen to have. Ms. Faint. Yes.
Sorry, ma'am, before we move on to the maps, I'm sorry to interrupt, but can I just make 2 points in response to some of the submissions you've heard from other counsel and Ms. Sykes in particular. First of all, in terms of the best endeavours obligations, I just wanted to be clear that my instructions from Te Aitanga Amahaki are to have this inquiry underway as soon as reasonably possible. So, and we can be ready to go, it appears, much sooner than Ms. Sykes' clients for the reasons that she's given, and some of the others are still looking for researchers. But it seems to me that to focus everyone's minds, it would be important to have evidence filing deadlines imposed immediately after this conference, so that everyone has a target to work to, because in my experience with researchers, it takes as long as it takes until they get a deadline. So I would encourage an early deadline setting for the first quarter of next year. And then the second point in relation to the mediation, and I think my friends Mr. Bennion and Mr. Lyle would support these submissions. Our clients don't support the mediation proposal. They're not saying no, but they are saying, well, they would need to see the evidence before making a decision. It seems to me that that proposal can sit out to the side independent of the inquiry planning process, because even after evidence and research has been filed, there's still going to be a couple of months available before the hearing, so it will be possible to have a mediation should that be what people want to do. I mean, the reason for my client's position is they don't think the customary interests are nearly as complex as perhaps Ms. Sykes is suggesting, but happy to be persuaded otherwise. So just wanted to be clear that that's what their thinking is at the moment.
Thank you, Ms. Faint. Mr. Bennion?
Yes, just to support that. I mean, I don't see that there's too much gap actually between us, because I know Ms. Sykes was saying, let's get the evidence in and then have a look. And we would formally say at the moment, mediation is not sort of formally accepted at the moment, but not formally off the table either. But even a sort of just as a practical matter, a sort of a discussion among parties and kaimātua, maybe narrowing issues even, would be useful. So all of those options are possible, perhaps as a mediation, perhaps as an issues narrowing situation. But again, I think we're all seem to be on the same page that at least evidence happens first, and then we start to have a look at that and see how we proceed forward from there.
Yeah, thank you, Mr. Bennion. Mr. Lyle, did you have anything you wish to add?
No separation from Mr. Bennion. Our clients have agreed the position in advance of the judicial conference there.
Thank you, Mr. Lyle. And Mr. Kauhikua, you've given your views on the mediation aspect of things already, so I won't ask you to repeat that. I think if I make some comments about the mediation matter now, that it does seem to me that we've got time between now and the filing of evidence, and I am looking to set some filing dates because, all due respect to Mr. Hamer, who's sitting next to me and is an ex-researcher for the tribunal, yes, work does tend to expand to take the time available, so the sooner we put a date in, the better. So there is some time between now and then, and I would encourage further discussions amongst council as the research comes in and is shared amongst claimants before it actually gets formally filed with the tribunal, that there may be opportunities at that stage to, because it certainly would help the hearing process not to have a long process regarding customary interests, because it would take up the 2 weeks and possibly more, and then we'd still have the technical evidence and closing submissions and so on to deal with. So if I can encourage further discussions, informal discussions to be taking place, and then we can look at it again once the evidence is all filed. And I take Mr. Benion's suggestion as sort of a possible way forward as well, that if it turns out that as the discussions proceed, claimants feel that it would be helpful to have a facilitated discussion together or some kind of wānanga, that I welcome submissions from council on that for the tribunal to provide resources in terms of tribunal members to assist with that discussion. So if I can leave it there for now, and then, but if you can all keep it on your radar, and then from the tribunal's point of view, we will look at it formally again once the evidence is filed. So that's that. So back to the maps, which our panel members are very keen to have, because while some are familiar with these areas, others aren't, and having the maps would be really helpful. Perhaps if I start with you, Ms. Faint, in terms of any mapping that Te Aitanga Māhaki might wish to provide.
I am stumped on that one, Your Honour. I
must admit, I must admit, I imagined that the maps that had been provided for the Turanganui Akiwa inquiry would be the maps that Te Aitanga Māhaki and would be relying on.
We might wish to update them, but I think what we could do is do that in conjunction with our historian and file any maps at the same time as his evidence. Right. Te Aitanga Māhaki are not funded by Crown Forestry Rental Trust because they found the process unduly burdensome and bureaucratic, so it may be that CFRT will be able to fund a map book in conjunction with all claimant groups, or otherwise it may be that the Crown will be able to produce such a book. Because not ordinarily you'd have a inquiry map book that everyone could rely on.
Thank you, Ms. Faint.
So perhaps either the Crown or CFRT funded groups would be able to coordinate that.
All right, thank you, Ms. Faint.
Mum, can I intercept? I could actually shortcut this. If we set up a process today to get a map book done by the Crown Forest Rental Trust, I'm sure that my claimant group would facilitate that happening. We've just done a similar exercise in the Northeastern Bay Plenty Inquiry, where we've set a process, all map requests by X date. That's referred to Crown Forest Rental Trust with a proposal for that mapping to be provided. And rather than have it as my map book, it becomes a common resource for the tribunal, but it's funded from us, if that's helpful. I don't know if we got, but I've got to be careful here. I disclose I'm a member of the Crown Forest Rental Trust. That's why I just want to be careful what I'm saying here. I don't make decisions on those matters where I'm involved, but that there is funding available for that purpose, provided we all cooperate, or if there are quite distinct issues, perhaps the group that are Mangatu related do one map book, and then we do one map book, if that's helpful, but I don't really see that should happen. Yeah, that's my own view. But I'm happy to sponsor that. I've already taken instructions on that today. Because we did it in Whakatohea, we're quite happy to do the same thing here.
Right, thank you, Ms Sykes. That is a very helpful suggestion, and I will leave it to Council to liaise with you and sort that out. That would be very helpful. Thank you. So that's the maps. I think most parties except Te Aitanga Mahaki are now approved clients of CFRT. Please put up your hand.
Just can I get some directions from you? It would be really helpful if you say all map requests could be by X date. I don't know what that is in a direction, because that will give us more influence in getting a priority funding request to the Crown Forest Rental Trust. And I'm happy for one of my staff to coordinate it, although I'm not the best person at maps. There's Tom Benyon. I'm looking at all the Cartesian experts amongst us here, Bryce. The Crown even is better than me, I'll tell you that. From I'm just being honest about my my skills shortage.
If I can step in here, I don't know, no particular degrees in the Cartesian front, but I think, for example, Mr. Lyle and myself both have funding, and we are being asked by Anita Miles from CFRT, what are your maps? So obviously it seems like we can all coordinate something around all of the base maps, accurate base maps that are required. I'm sure we can organise something around requests for particular maps. I'm sure something can be coordinated amongst council, so happy to assist with that.
Thank you.
I'm sure Mr. Lyle will do.
Thank you, Mr. Benyon. And just in terms of the date that is expected in the Memorandum of Directions that's going to come out, I know Matua Kevin would have liked the maps yesterday or before, but when's a reasonable time to expect to put in the Memorandum Directions? Mr. Benyon? As the map expert?
Well, I would have thought that actually the Crown could help with this too, because I think the base maps from Tūlanga, etc., are all out there, and it might actually assist parties with research as well. So perhaps a date later this year might be a good one for mapping. I don't know that it has to wait till well into next year, although there's two sets of maps. So there will be the maps of all the blocks where the session line runs, those sort of matters. Then there's the other set, which is claimants saying here is where we say particular battle sites occurred, here is we say particular trails over the mountains would have been, here's where kainga were, those sorts of matters. And there might be variability in those, and those second maps might relate a little bit more to the evidence as it's produced by researchers and as kaumātua prepare their evidence. So perhaps at least a date which says we can get a good series of maps this year which set out the Crown information, if we could put it that way, around boundaries, and native land court information sometime this year, November, December, something like that, and then maybe other maps could be the second date, but again, still setting a date perhaps with the sometime in the first quarter of next year would be my sort of off-the-cuff proposal.
Thank you, Mr. Benyon. Mr. Lincoln, did you have any submissions on that matter?
Kia ora, Your Honour. That's really interesting exchanges. Yes, I think there could be something in this to pull together they're essentially a bunch of existing resources, as I understand what Mr. Benyon was just saying, including pulling it together from adjacent inquiry material. And we would, I think, be very happy to, collaborate with Claimant Council on identifying that, listing it and producing it, and agree that circulating, we'll call it sort of state-based information, perhaps for sort of a working title. Circulating that by the end of this year would be a really constructive thing to do to help orient everyone. So yes, what would the direction look like? Well, I think if you give us all an outcome date, and if you want to communicate an expectation that the Crown will take the lead in sort of actually getting it filed, but would very much be looking to do it in collaboration with my learned friends.
Kia ora. Thank you, Mr. Lincoln. The date that's popped into my head for filing is the 17th of December, which would be pretty close to the end of business this year. So if we're looking at that sort of date. I think we've covered most things except the jurisdictional matters raised by the Crown. The reason why this is on the agenda is that obviously this will be a matter for legal submissions, and my understanding of the various memoranda that have been filed is that it's intended that those issues as to jurisdiction be raised during the comprehensive hearing, rather than having a jurisdictional hearing beforehand and then going into the substantive evidence. And I just wanted to clarify and see if my understanding of that is correct. So, Ms. Faint?
Yes, that's correct, ma'am. So there are two reasons for that approach. One is we think that an understanding of the evidence may be required in order for the tribunal to reach its decision on jurisdictional matters, because it may rely on whakapapa evidence in terms of what's been settled and what hasn't. And the second reason is we don't want to be derailed by a judicial review in relation to a preliminary decision on jurisdictional matters, because that could mean that the substantive hearing is postponed by several years as it winds its way through the courts. So I think all parties, including the Crown, are agreed that we deal with all issues in one comprehensive inquiry.
Right, thank you, Ms. Faint. And I'm taking it that everyone who did sign the joint memorandum is of the same view. So I just need to check in with you, Mr. Kahukiwa.
No submissions on this matter at the moment, no.
Thank you, Mr. Kahukiwa. So that is that. Any other business that anyone wishes to raise at this time?
Your Honour, just to follow up on the Y499 issue, following the passing of Ms. Brown, we're still working with the potential claimants who will be stepping into the gap left by her passing, and appreciate that extensions have been granted for resolving that already, but further time is going to be needed, and we're hoping to have that resolved by the end of this month at the latest.
Thank you, Mr. Lyle. And just Ms. Dixon, in relation to an amended statement of claim for Te Whānau Kai, it's still open at the moment, if I can put it that way. And you've heard me say that the very last date for amending any statement of claim will be the date of filing of claimant evidence. But preferably, we would like to see Te Whānau Kai file any amended statement of claim as soon as possible. Can you give us a time frame for that?
Yes, thank you, ma'am, and grateful for the indication. It is looking like for administrative purposes, we do want to get the statement of claim in at least by the 30th of September. It carries with it advantages in terms of dealing with CFRT and, of course, with the tribunal and other funding issues. And so if we can get the initial statement of claim in by the 30th of September, and then, of course, abide your directions in terms of amending that once we have a better view of the evidence.
Thank you, Ms. Dixon. Is Ms. Miles? I can't see her here. I just wanted to check with her whether the tribunal would have to give another confirmation that Te Whānau Kai is included in the inquiry, and because we were waiting for the Ms. Sykes in relation to the Motohoro claim, we were waiting for some confirmation as well whether they were going to take an active part in the inquiry. I'm just checking whether the tribunal needs, because CFRT asks us if who was in the inquiry, who was taking part. So I'm just checking if we have to do another.
If it will help for a policy position, we need to have an information available for any trustee's decision at least 3 weeks in advance, ma'am.
Right.
So if my friend wants to get funded, then I think we meet around the third week of every month. So, her proposal would meet that meeting time for next month, but no guarantee because Ms. Miles would know what their workloads are like. So that's all I'm saying. But I'm instructed by Ms. Cole to seek the first week of October for a filing date. She's involved at the moment in the geothermal hearings, and that's why she's not here today, but she was anticipating having an amended statement of claim to confirm participation here by the end of the first week of October. That was my instructions. I don't know if the 30th of September is available to her, ma'am. I'll have to check.
All right, thank you, Ms. Sykes. Well, I'll put the 30th of September in the Memorandum of Directions, but obviously from our point of view, we would give more time, but in terms of CFRT and so forth, that would be helpful on that side of things for the claimants. I'll just check with the tribunal panel if they have any questions that they wish to ask. Professor Williams?
No questions, but I was just catching up. Is it Dame Joan Metch that Annette says has died?
Yes.
Oh. Yes, sir.
Oh, well, moi mai rā, Kaurangi Joan. Yeah, she was my kaiako in 1969, and I saw her just 3 or 4 months ago. So, yeah. Judge, I've got no questions. But I'm a little bit shocked by that news. Not shocked because she's 98 or something, but anyway, sad. Yes.
Indeed. Mr. Crump?
Thank you. No, that's been very helpful today, but no questions.
Thank you. Did you hit me?
Kia ora, it's Paul Hamer here. I just going back to something Mr. Kahukiwa said, which was the suggested inclusion of a block, was it Mangatai Kapua or something like that? I just thought that was slightly left hanging as to whether any other council supported that idea, and I, for one, don't know where that block is exactly. So I just thought I'd mention that.
Ms Sykes here, we would support it just because we don't want to keep coming back to the tribunal on a truncated basis. And the boundary he gave us in terms of co-location to Mangatu number 1 certainly is part of our historical context in this case. So I would support it being included.
What I'll do is ask for Council in the memorandum of directions that we'll issue, ask Council to indicate whether their claimants support its inclusion. I would like to get the boundary settled fairly soon, and so we will await any further submissions on that after the memorandum of directions issues, and then consider it. And also we'll just need to try and find a map that shows it. Kia ora, Ms. Bain.
Yeah, Ms. Bain here. The approach that our historian is taking is to research all the blocks surrounding the Waipaoa blocks as well, on the basis that they may give further information about customary interests. So I think there might be a distinction between what's relevant for contextual purposes and what's relevant in terms of the actual claim. And without looking at a map of the blocks, I can't say exactly how far out we're going, but it would be helpful to have confirmation from Mr. Kahakiwa of what that block that he was talking about was called.
Yes, thank you. Manga Tai Kapua, is that correct, Mr. Kahakiwa?
Yes, Manga Tai Kapua. It's on the map, Y1750 hashtag 3.1.433 bracket A bracket. That came up in, I think someone refiled it or something, but yeah, it's quite clearly marked on that map, and it's, as I say, the western boundary of Mangatai Kapua is shared with Mangatu number 1, and the northern boundary of Mangatai Kapua is shared with Waipaoa number 2. So it sits to the southern part of the Waipaoa block and the Mangatu block, if you like.
Okay, has it got a boundary with the Waipaoa River? Is that what?
Yes, I think that's right. Yeah, I can't quite see it.
All right.
Scale on this map. Yeah.
Thank you, Mr. Kahukiwa. We will find the map that you've referred to and perhaps send it out, a copy of it out with the memorandum directions.
That would be very helpful, thank you.
Yeah. And Matua Kevin, did you have any questions that you wanted to ask before we close?
No, I have no questions. Thank you, Judge.
Right, thank you. Well, thank you very much, everyone, for your attendance today and for some interesting and helpful discussion that we've had today. As you've heard, I will be issuing a memorandum of directions which will be laying out some deadlines for filing and so forth. And hopefully we can move forward with this inquiry. I just also note the information provided by Ms. Faint that the Court of Appeal decision in the Mangatu remedies matter will be out, fingers crossed, in October, and that will give everyone some food for thought, I'm sure. All right, so thank you again, and I'll ask our kaumātua to close for us.
Kei nei tātou, e te atu kaharawa, e te atu ātawhai, e tuku tunu no mātou tēnei reo whakawhetai, whakamoimiti ki a koe pā, mo ngā tini manaakitanga I hō mai koe ki a mātou, I roto I tēnei hono I te purangi te rānei. O te ino tiki a koe I aenei pā ki a manaki tunu koe I a mātou e atangi o mātou mahi. Manaki tino hoki ngā au e hakako atu ngā kaupapa, kia puta pene pai ngana mo te iwi whai pāngana ki Waipaoa. Te ino ki tēnei ki a koe pā mau ne whakamana mai. I runga ne te ngua tāu tamatikai whakoro koe I Karaiti. Āmene.
Amen.
Kia ora.
Kia ora. Could I just ask the tribunal panel members just to stay on the line? Thanks.
Okay. Okay.